Welcome to Prince Shorthand House. Exercise number 53, legal real judgments, 100 words a minute. Ready? Start. The petitioner also deposited the re-inspection charges. However, the fact of the matter is that in spite of the intimation and the deposit of the re-inspection charges, the objector never carried out any inspection for many years, and which inspection was only done on 5th May 1994, and which inspection in any case showed that there was no concern in the name of MS Delta Electronics Private Limited in the subject premises. On the aspect of load violation charges, the arbitrator has referred to the various provisions of the tariff rules defining connected load and sanctioned load. The arbitrator, on reference to the definitions, has found that the issue therefore pertains to violation of the sanctioned load only and not the connected load, inasmuch as the MDI instrument did not support the stand of the objector that the load as found in the inspection dated 7 September 1989 was used by the petitioner. The scope of hearing objections to an award by means of a petition under section 30 and 33 of the Arbitration Act 1940 is well settled. It is necessary before the court can interfere with the award that the arbitrator must have misconducted himself or the proceedings. If the arbitrator takes one plausible view, then it cannot be said that the arbitrator has misconducted himself or the proceedings merely because another view is possible from the same facts and circumstances on both the issues of load violation charges and misuse charges. The arbitrator has referred to the relevant provisions of the tariff rules, the provisions of the agreement, various documents, and the facts of the case to give one interpretation. This was thus a plausible view. Accordingly, this court has no jurisdiction to interfere with such findings and interpretation, as the said findings and interpretation are not perverse and one which only an unreasonable man could have taken. I am thus not inclined to interfere with the findings in the award. Further, it is a settled law that an arbitrator is the final fact-finding authority. The arbitrator has found as a matter of fact that the show cause notice was not given. He has further found as a fact that concerns are sister concerns. He has further found that the maximum demand indicator did not indicate load violation charge. There are various other findings in the detailed award of the arbitrator running into 38 pages. The arbitrator has recorded in detail all the arguments raised by the counsel for the parties, the relevant provisions of the tariff rules, the relevant provisions of the agreement, and the relevant documents, and has therefore given valid and reasonable basis to arrive at his conclusions and findings. By doing so, in my opinion, the award falls out of the scope of challenge on the ground of the arbitrator having misconducted himself or the proceedings in passing the award. Mr. Vikram, advocate appearing for the NDPL, has canvassed that the rate of interest granted by award is excessive. I am in fact distressed that such an objection has been raised because the arbitrator has only awarded interest at 9% per annum simple. In view of this position, I fail to understand how this argument can at all be canvassed that the rate of interest is in any manner excessive. I do not therefore find any reason whatsoever to sustain this objection to reduce the rate of interest awarded. More so as the dictums are charging interest varying by 18% to 24% for the payment due to it from the consumers. In view of the above, I find no force in the objections which are dismissed, leaving the parties to bear their own costs. Stop.